Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. On behalf of Judge Bennett and Judge McBrayer, we're pleased to welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to keep the courts open to the public. We will conduct the hearing in the same manner as if we were in the courtroom. Each of you has 15 minutes, and the appellant had reserved some of that for his rebuttal. Unless there are any announcements, I'll ask Ms. Lindsay to call the case.
Emergency Medical Care Facilities, PC versus Division of Tenncare et al.
All right, thank you, and we're now ready to hear your arguments.
May it please the court. Good afternoon, I'm Matthew Dykstra from the Tennessee Attorney General's Office, and I represent Tenncare in this matter. In 2011, Tenncare was facing a budget shortfall to the tune of about $120 million. To offset a portion of that deficit, Tenncare implemented a $50 reimbursement cap that applied to emergency room providers who were contracted with Tenncare and that provided non-emergent care in emergency rooms.
Let me just ask about the process a little bit. Tenncare proposed a budget with the $120 million worth of cuts to the governor, right? At the governor's direction, I assume. And then the governor proposes the budget to the legislature that had these cuts. Was it understood by everyone that these cuts included this $50 fee?
I don't believe the $50 amount was specified. What was specified was that the savings, which were approximately $25 million, would come from reduced reimbursement to emergency room physicians for non-emergent care.
So everybody knew this was coming?
Yes.
Okay.
And the Chancery Court below ruled that the $50 cap was void for lack of rulemaking. Tenncare asserts the Chancery Court got it wrong for three reasons, any one of which requires reversal. First, the $50 cap does not meet the UAPA's general definition of a rule. Second, even if it did, the $50 cap satisfies the internal management exception to that general definition. Third, and directly unrelated to the UAPA, the Tennessee Medical Assistance Act provides Tenncare with a rulemaking exemption for cost control measures like the $50 cap. I'd like to first talk about the definition of a rule. It's defined in our code at 4-5-10212. And it says a rule means any statement of general applicability that implements law or policy. So from the outset, this language tells us that not all agency statements, even when they implement law or policy, will constitute rules. Instead, only those agency statements that are generally applicable will. That phrase, general applicability, is a limitation on what constitutes a rule, and it must be given effect. To do that, there must be agency statements, again, even if they implement law or policy, that are specific enough to avoid the definition of a rule. Tenncare's argument on this first point really springs from this premise. Again, that is, there must be agency statements that are sufficiently specific to not be generally applicable. And that's what we have here with the $50 cap. $50 cap did not apply to all healthcare providers. It did not even apply to all emergency room providers. Instead, it narrowly applied to emergency room providers under contract with Tenncare who provided non-emergent care in emergency rooms.
Had it applied to all healthcare providers, would it then necessarily have been a rule or had to follow rulemaking procedures?
I think that, I hate to speak to hypotheticals, but yes, in terms of the general definition of a rule, the type of rate reduction, if it applies, you look at the type of rate reduction and then its target. Does it apply uniformly across all healthcare providers? Certainly so. I want to be clear, though, that there's still the internal management exception, and there's still this other exemption that we'll talk about. But going back to this specificity versus generality question, I undertook this exercise, and I think a useful exercise is to ask, how could the $50 cap be any more specific? Could it be further narrowed by specifying that it only applied to one of our state's grand divisions? Could it be further narrowed temporally and to say that it only applied to services rendered on Monday, Wednesdays, and Fridays? I think the answer is that the $50 cap is already as specific as practically possible. Or in other words, not generally applicable. So on this first point, Tenncare asserts that we don't fit the general definition of a rule. Even if the court disagrees with Tenncare there's an internal management exception. And that says that even if agency statements constitute a rule, they're not subject to rulemaking if they only concern the internal management of state government, and basically they don't affect on the public. A few years ago in the Tennessee Community Organizations case, this court examined the contours of that exception, the internal management exception. And it held that when a policy is mandatory only on agency employees and contracted entities, then the internal management exception is satisfied. And that's what we have here. The $50 cap is only applicable to entities contracted with Tenncare. We also cite in our brief an Attorney General opinion that speaks to that same issue. I think the thought there is consistent. If it only applies to employees and contracted entities, then it meets the internal management exception.
So it has no impact on a Tenncare recipient.
There certainly isn't anything in the record as far as evidence saying or supporting that it has an impact. I know EMCF has argued in the brief that it could, and they argue about downstream impacts. They cite no case law supporting that. It's just supposition. There's no evidence to that.
So their costs don't go up. They don't have a higher copay. There's nothing in the record that says that there's anything that they're affected in any way by this.
I do not believe so.
Okay.
And that question, I think, gets to the fact that rulemaking on the UAPA is a very fact-specific, case-specific inquiry. I'd like to now move to something that's less fact-specific, and that's the provision of the Tennessee Medical Assistance Act that we cite extensively in our brief, 71-5-102D. This is really a matter of straight statutory interpretation. Now, I'd like to divide my analysis on this into the scope of the statute and then what the statute means. On the scope, I think there's a threshold issue. Are healthcare providers within the scope of the statute? EMCF maintains they're not, and that the statute is limited to enrollee costs. I think we look, like with any statutory interpretation case, we start with the text of the statute. And the statute's very first sentence, it says Tenncare shall have the authority to control the costs of the Tenncare program. There's no modifier before costs. There is no limitation. It does not say Tenncare shall have the authority to control enrollee costs. EMCF reads that limitation in. If the plain language isn't enough, the public act behind the statute says that the purpose of 102D was to control the overall expenditures of Tenncare. Overall. Excluding provider costs from providers generally from the statute simply cannot be reconciled with the phrase overall expenditure. And if there's any ambiguity, and I don't think there is, then Governor Bredesen's speech, I think, resolves that ambiguity. His speech was to save Tenncare. Tenncare at the time was consuming 91% of all state revenues. Provider costs and enrollee costs are the two big buckets. I don't think you save a program by nibbling around the edges. I think you're looking for a global solution. And in fact, Governor Bredesen mentioned provider costs and said the state needed to take the reins back and decide how much and for what we are going to pay. So on the issue of scope, I think it's clear that providers are within the statute. the next question then is, what does that mean? Well, it means they're exempt from rulemaking for cost control measures. There is in the authority is in segment A of the statute, its first sentence. We denoted as segment A. It's confirmed in segment D, where it says they shall have all such authority to control costs, notwithstanding any other state law to the contrary. EMCF's position is that the UAPA needs to be explicitly referenced there for the statute to control. We cited case law in our brief. That's just simply not the way statutes are interpreted. Excuse me. I don't think that's the way legislators work either. I don't think when they want a statute to trump all other statutes, they sit down and go through the entire code and list out every specific statute. I realize I'm coming up on the end of my time here. I'll go into a little bit of my rebuttal time if there's any questions.
All right, we'll hear from you on rebuttal. Mr. Reynolds?
Thank you. May it please the court, Greg Reynolds for the appellee, Emergency Medical Care Facilities, or EMCF. What the court must decide here today is whether Tenncare can issue a mandatory pay cut to every physician in every emergency room across the state simply by sending an email to its MCOs without any public notice, without any participation in the process by the public, without any review or comment, and without the review that normally accompanies rulemaking under the Tennessee Uniform Administrative Procedure Act, the TUAPA. We respectfully submit that the trial court got it exactly correct when it held that the $50 cap is in fact a rule, and Tenncare does not have some broad exemption that exempts it from rulemaking whenever it acts to control costs of the program. Tenncare advances 3 arguments on appeal that are all largely unsupported. They are result-oriented and respectfully incorrect. Most importantly, however, the court should know that the paths of each such argument that Tenncare makes lead inevitably to the same destination, and that is that Tenncare virtually never would have to engage in rulemaking. First, Tenncare says the $50 cap is not a statement of general applicability. In making this argument, which I would point out to the court is entirely unsupported by any authority, Tenncare simply says this $50 cap is not of general applicability because it only applies to every emergency room physician. It doesn't apply to every healthcare provider in Tennessee. They say further, it only applies to contracted emergency care providers, but that ignores the reality that every emergency care provider, every emergency care physician in Tennessee is a participating provider. Everyone that participates in Tenncare is a participating provider. Therefore,
is it true that all emergency room physicians then participate in Tenncare to some degree, either as in-network or out-of-network?
Your Honor, I can't speak to that dispositively. However, I will point out to the court, and the court's probably aware of this, there is a federal statute called EMTALA that mandates that emergency care physicians in hospital emergency rooms treat all patients that present to the emergency room. They have to treat them and assess them, and if necessary, stabilize them. And so, yes, as a matter of practice, as a matter of law, federal law, all Tennessee emergency care physicians must treat Tenncare recipients that show up in the emergency rooms.
And it is, I'm sorry, I got a little lost in your point, I suppose. Your point is it's general applicability because every emergency room doctor ends up treating a Tenncare patient at some point.
That is part of it, Your Honor. There are other things as well. First, the TUAPA is in fact a Uniform Administrative Procedure Act. It hails from 1961, and it has the language of the Uniform Act. The Uniform Act was enacted in 1961. It makes clear what this language means. This Uniform Act uses the language general applicability, and it says, quote, rules like statutory provisions may be of general applicability, even though they may be of immediate concern only to a single person or corporation, provided the form is general and others who may qualify in the future will fall within its provisions. I'm quoting from the official comments to the Section 1 of the 1961 Uniform Act. In 1981, the official comment says this, quote, a rule is an agency statement establishing law or policy of general applicability in italics. And then it says, comma, that is applicable to all members of a described class. There is no dispute that in this case, the $50 cap applies to all emergency physicians. All emergency physicians in Tennessee get this pay cut. So therefore, the test, this specificity test, is a red herring. There is no such thing under the Uniform Act. There is no such requirement under the TUAPA. Instead, it is merely the distinction between rules and orders. Orders are to specific named persons. Rules are to categories of people. This fits the definition of general applicability under the rule. Chancellor Martin her opinion was entirely consistent with this understanding of the definition of general applicability. She wrote, quote, Tenncare cannot avoid the general applicability label by determining different reimbursement rates on a class-by-class basis to particular types of services, close quote. Here, there's no dispute that the $50 cap applies to all reimbursements of emergency physicians in the state. So therefore, it is, as a matter of law, a statement of general applicability, and Tenncare's first argument should be rejected. Second, Tenncare argues that this $50 cap satisfies the exemption in 4-5-10212A, which is for statements, and this is key, it says statements concerning only internal management of state government and not affecting private rights, privileges, or procedures available to the public. Tennessee bases its entire argument on this one-page adhesion form, the participating agreement, the participation agreement. That agreement does not specifically say anything about forfeiting rights. It requires the provider to, quote, provide medical assistance at or above recognized standards of practice. and includes a provision requiring the compliance with contractual terms and Medicaid policies. If Tenncare's position is correct, then it would virtually never have to engage in rulemaking, because think about this. Every participating provider must sign this one-page adhesion contract. And therefore, every participating provider, every provider in the state, ultimately and unwittingly, I would say, forfeits their rights, their private rights, just by participating in a program, Tenncare program.
Well, who is the state and its agents, and who is the rest of the group? I mean, an internal management of state government. I mean, doesn't that include the state and its agents? And the state can instruct its agents or pay its agents a certain way. And if it doesn't affect the public in general, why isn't it an internal management? It doesn't, as Mr. Dykstra said, there's nothing in the record that says the public in general is affected. It's just the state dealing with its contractors. Why isn't that an internal state management?
Because
to fit the exception.
Because, Your Honor, the contractors are not agents of the state. In fact, Tenncare makes this very clear.
Well, okay, they're contractors with the state.
Yes, that's true. Now, I think, Your Honor, this is really well thought through in Judge Clement's opinion in the Heritage case. In that case, the agency tried to take this same contract argument and tried to say that its policy provisions in its manual were binding on contractors, on participating providers, simply by virtue of the fact that they signed it, and that made applicable the internal management exception. Judge Clement, in his opinion, rejected that and noted that provisions such as the policy in that place that affected how much providers could be paid, could charge, were clearly rules, and that this exception doesn't apply. And he also noted in his opinion that these are procedures available to the public, i.e. participating providers. In other words, he stated clearly that participating providers are members of the public for purposes of that exception, and therefore it doesn't apply to matters that impact them directly, like cutting their pay.
What about the case that Mr. General Dykstra cited, Tennessee community organizations, where the line seemed to have been drawn between the public and on one side and the state and its contractors on the other? I would note that Judge Clement and Judge McBrayer participated in that one. So,
yes, Your Honor.
What's different?
A lot is different. There was an entire statutory scheme in work there that provided for operating guidelines that had their own procedure for adoption that was separate and apart from the TUAPA. This was, as they found, an operating guideline and not a rule. Second, there was no dispute in that case that if it had been a measure that determined the payment to participating providers, it had to be established by a rule under the TUAPA. And so that case is entirely consistent with our argument here that you cannot act to cut pay of participating providers without engaging in rulemaking. And I would further cite to the court, there is a statute in the Tenncare law that specifically addresses this. It is 71-5-105A3. And it says in particular that Tenncare must engage in rulemaking for, quote, the determination of payment for hospitals, comma, and other healthcare providers who contract with the department for the care of persons eligible for assistance pursuant to this part. So this
what
question,
does determination of payment mean? Figuring out the amount or what?
well, I would submit that the $50 cap says the amount shall be no more than $50. That is the determination of payment to a participating provider. Under Tennessee law, this is specifically something that requires rulemaking. Now, if I only have 30 seconds left, but I'd like to address the last argument. That is what I call the super agency argument.
Better do it fast.
There is nothing in 102D that explicitly or even implicitly relieves Tenncare of its obligation to engage in rulemaking. Moreover, the procedures required under the UAPA are not contrary laws, and therefore they're entirely consistent with Tenncare's obligations as it recognized when it submitted its first notice that promised to do emergency rulemakings in order to make the $50 cap law. Thank you.
All right. Thank you, Mr. Reynolds. General Dykstra, you have rebuttal.
Touch on a few points here. The first is the phrase I heard Mr. Reynolds say, I think 3 times, which is Tenncare's position in this case is that it never has to engage in rulemaking. That's not true. What Tenncare has alleged is that in the first case, this was a very specific application under the UAPA. Under the Tennessee Medical Assistance Act, its rulemaking exemption is only for cost control measures. And there is no dispute that the record in this case, factually, established that a cost control measure was necessary. This does not speak to other areas such as rates that the public are charged or conditions of enrollment in the state program, conditions of disenrollment from a state program, sanctions policies in the state program, appeals rights in the state program. Every case is fact specific, and Tenncare is not maintaining that it has carte blanche over every aspect of its operations. What it has is authority that derives from a historic statute that was enacted to counter a historic problem. And that was limited to costs. So its rulemaking exemption that we're advocating for here is limited. It is not what Mr. Reynolds says, that Tenncare asserts that they never have to engage in rulemaking. Really quick on this EMTALA issue, EMTALA does not require providers of any kind to sign any contract. It does not require them to to enroll in any private insurance program or state-run insurance program.
I'm sorry, what is this?
This is the federal statute, which we've abbreviated as EMTALA. I don't remember exactly what that acronym stands for, but it's part of your discussion with Mr. Reynolds. So it's really irrelevant here. And I think that its irrelevancy is highlighted by the fact that EMCF never argued it in any of its briefs. This was something that Chancellor Martin brought up on her own. Respectfully, I think that the odds of misapplying law or getting it wrong increase a bit when you don't have the benefit of parties' argument in briefs. And really, I think that's what happened.
But the federal law does compel an emergency room physician to treat a patient who presents at the ER. And it does not allow that physician to say, this is not an emergency situation. You do not need immediate treatment, and you can go to see hourly clinic. It seems to force the physician to provide a service against his or her wishes. I think that's relevant.
It does impose an obligation on emergency room physicians. We do not dispute that.
So
I
federal
believe it's
law compels the physician to provide a service, even if it's not an emergency. And the state says, and if you do this, we're not going to give you a penny over $50. That's a hard spot to be in.
And that's the Medicaid systems and state plans are complicated, and there is interaction with federal law.
Which is why the collaborative rulemaking process is advisable instead of letting somebody send out an email.
Again, our position is that EMTALA does not require emergency room physicians to sign anything.
They can go work for Hiller Plumbing and Electrical, but they can't work in the emergency room.
I understand the concerns expressed, Your Honor. We still think that the law is on our side on this. And with a minute left, I really want to address Section 75.5.105A3. And to your question to Mr. Reynolds, Judge Bennett, that statute does not require Tenncare to promulgate rules that establish specific reimbursement rates. The statute's language is establish rules for the determination of payment. So we've argued that the statute doesn't apply here. Even if it does, Tenncare has complied. I believe it's on pages 10 to 12 of our opening brief. We lay out the rules that Tenncare has implemented through formal rulemaking, notice and comment rulemaking. It's the full payment rule and the 80% rule. And both of those satisfy the standard of rules for the determination of payment. 71.5.105 is just really not relevant to this dispute. On that, I'd like to conclude by saying that the court should reverse the Chancery Court's decision, vacate the Chancery Court's order denying Tenncare's motions for summary judgment with directions to grant summary judgment in favor of Tenncare. I appreciate your time.
Thank you, General Dykstra and Mr. Reynolds, for your arguments. And I'd like to say I compliment each or both of you for excellent in-depth arguments. You've given us a lot to think about. We'll take this matter under advisement. Ms. Lindsay.
Thank you, Your Honors.
Honorable Court of Appeals is in recess until 2 p.m.
Thank you, counsel, and you're free to exit the Zoom meeting.
Thank you.